Well, good afternoon, Bill O'Leary, coming to you this Thursday. Today is July 8th. Hopefully, everybody's 4th of July holiday this past weekend went well, and I also hope everybody survived that tropical storm that came through. Really wasn't much of anything. So here we are on Thursday, and this is part of our Thirsty Thursday series. And so what this is a series where I go live on Facebook every Thursday and talk about a topic or an issue of sort of about what I do. I'm an estate planning and elder law lawyer. And so again, it's a topic of interest that relates to those areas of law. So if you're thirsting for knowledge, you've come to the right place. Today's topic is, I think, fairly interesting. What happens to your online content when you die? What happens to your online content when you die? Look, everybody, every one of us has online content. Frankly, a lot of times content that we're not even aware of. In fact, the average person in this country has well over 100, probably now, probably over 150 online accounts of one sort or another. And so most Americans have no idea how these accounts will be handled after they die. So, look, in the estate planning world, the world I live in, these online accounts are given a name, and it's what we call digital assets. Digital assets, they include any really online account that requires a login and a password, like email or maybe online bill pay. Digital assets can also include, let's say, shopping sites like Amazon, eBay, and PayPal. What about travel rewards accounts? How about, apps or subscriptions, podcasts? How about photographs and music libraries and social media sites, big ones? Again, these are all known as digital assets. Even health records are increasingly being archived online. Digital assets, they include all of your devices like computers, laptops, smartphones, tablets, e-readers, those sorts of things. And many computers, frankly, automatically back up data storage on the cloud, which may lead to intellectual and sentimental property. So think for a moment how many emails that you have. Think how email has taken the place of traditional paper letters. What about photographs? When's the last time you came across a shoebox with old photographs in them? Nowadays, people store them in the cloud. They archive their photos and their memories, in the cloud. These accounts hold real value, and frankly, they should be preserved. So think of it as a digital footprint. And so that digital footprint, once you pass away, what you leave behind can be filled with surprises. And frankly, the time required to carry out the final wishes for these sort of digital assets or online content or accounts is time consuming and complicated. So I want to just share a sort of a case example. Consider the case of Betsy. She was 68 years old when she died, and when she died, she had over about 110 online accounts. And here are just some of the accounts or digital assets that she had. She had an email account with Gmail, a Gmail account. She had 3 online credit card accounts, several online shopping accounts like she had a PayPal and an Amazon and an eBay account. She had some retail store accounts online as well. She had a number of rewards accounts like airlines, car rental companies, even a pet store, and then several department stores. She had online banking accounts. She happened to do her banking at the Bank of America and Wells Fargo. And she also had, in addition to banking accounts online, she had online investment accounts. She happened to have Schwab, Fidelity, and Vanguard. She had several online accounts with charities that she donated to. She had social media accounts. She had a LinkedIn account. She had an Instagram, and she had a Facebook account as well. She had subscriptions to Netflix and Hulu, along with various magazines. She had memberships, online membership accounts, 2 in particular, AAA and AARP, and online utility accounts with, in her case, Time Warner, Verizon, along with the local electric company and the gas company. That's just a sampling of what she had. That's a lot of online accounts and a lot of storage in the cloud. she didn't leave behind a plan for how these accounts would be accessed after she died. So let me tell you what it cost her estate to figure it out. Well, the lawyers had to spend a lot of time digging through that, sort of like an investigation, if you will, to track this stuff down. $19,000 in lawyer fees, another $12,000 to figure out how to obtain access to these accounts. Oh, by the way, there was an ID theft issue that cost $2,000 to resolve. Why? Because the ID theft occurred because Betsy's accounts lied dormant for an extended period after she died. I'm going to come back to that. Thieves will prey on inactive accounts after somebody dies. And on top of that, another $1,500 to reopen a new account after an account was determined to be lost. So the total cost of the estate for Betsy was $34,500, and it took over 300 hours to do all this work. And beyond that, imagine the emotional impact. How do you put a price tag on that? So let me take a minute and talk about. Talking about thieves and online ID theft. Let me tell you that your online accounts become an easy target after you die, which is why it's so important to set up instructions or directives ahead of time so your loved ones can gain quick access to your accounts and not allow for any time for a thief to do that. Look, ID theft is a big problem after you die. So here's a scenario that has occurred before. A bad guy is going to comb through the obituaries, and then they stumble across the deceased person's LinkedIn page, and from there they're going to find out the deceased person's last job position. Then they'll file a fraudulent tax return in the deceased person's name using the last job position. They'll get a refund sent to them, okay? Sent to the bad guy. And guess what is disclosed in the refund? The deceased person's Social Security number. They then take that Social Security number, go to open a bank account with a false ID, and then they open a credit card account and make purchases pretending to be the deceased person. And all of this happens fairly quickly. All of it occurs before an estate is open. Now, eventually, with work and cost, the mess is going to get cleaned up, but it's a tremendous and unnecessary cost to the estate, okay? Oh, and then what about Facebook? What about Facebook? Many of us have Facebook accounts as a way to stay in touch with family. Facebook can become a constant reminder, though, of a deceased loved one's death, as birthday and anniversary notifications pop up. They're sent out automatically every year. And what this does is it reopens the wound every year. It inflicts recurring emotional harm, if you will, on the surviving family members. Wouldn't it be nice to set instructions in place ahead of time to do something with that Facebook page? Because without advanced instructions, it's almost impossible to close down. Unlike tangible assets you can touch and feel, there are no deeds or title instruments for digital assets. There frankly is no paper trail. Oh, and what about creating a list of your passwords for your online accounts, your online passwords, and giving a copy of your password list to your family? Do you think that solves the problem? Password lists are not the solution, not even close. Here are some reasons why password lists should not be relied upon. Password lists become out of date quickly. We're constantly asked to update our passwords. Do you want to take the chance that you won't forget to constantly update your password list as you're updating your passwords, and that your password list will be current and up to date when you die? Want to take that chance? And then you have the issue of two-factor authentication, very common these days, where you have to double authenticate, maybe through a text. Will your loved one be able to successfully navigate the two-factor authentication process after you die? And then the issue of IP address tracking is becoming increasingly effective. Each computer and smartphone has a unique IP address, and when you set up an online account, either on the computer or the phone, the online provider or platform knows what computer or phone you used. So what would happen if a family member tries to access your online account from a different computer or a different smartphone? Do you think that they will know that the access is being attempted from a different device? Do you think the platform or custodian will know? Probably so. Will they shut off access suspecting that fraud or theft is occurring? Do you want to take the chance that your loved ones can't access your accounts? You know, and then technology, of course, is evolving to where passwords at some point will become obsolete. You know, the whole issue of biometric identification is fast becoming a way to verify identity. At some point, we're not going to be using passwords anymore to access online accounts, but instead we'll be using personal identifying markers like maybe retina scans or facial recognition. Your loved ones don't have the same retina or facial features that you do. They'll be denied access to your online accounts because they're not you. There's only one of you. And perhaps most scary is the fact that when you use someone else's password to access an online account, it violates 2 federal laws in addition to violating that particular, platform or provider's what's called terms of service agreement. And without getting into a detailed legal discussion of what those laws say or what this terms of service contract says, just understand you place your family in great legal jeopardy by just giving them a password list. So wouldn't it be nice to provide clear instructions for all of your online accounts, instructions ahead of time before you die, so that your loved ones will know what to do with them and can easily access them? And wouldn't it be nice to set up your digital assets now in a way so that they'll not be vulnerable to fraud or cyber threats after you're gone? Well, we have a solution, in fact, a solution that we make available to our valued clients who are also members of our client care program. The solution is a secure platform that allows you to create a list of your digital accounts and assign directions or directives for how you want those accounts handled after you die. The platform simplifies the organization of all your digital assets and their instructions or directives after you die. The account holder's final instructions are clear and expressly done. You may decide, well, who do you want to give access to the account to? Do you want to give access to this person? Maybe do you want to deny access to somebody else? Do you want to give full and complete access, or maybe limited or restricted access? What do you want to do with the account? Do you want it to be left open so your loved ones can access it? Maybe it's an account that you want to keep private and have nobody know about it, and so you can give advanced instructions to have the account closed right away after you die. The platform is a proprietary technology that we partner with, and this is constantly being updated to comply with the ever-changing terms of service agreement that these online providers have. That's the long list of legalese that you never read, but you have to accept at the end. You have to click accept in order to set up the account. Now, importantly, this solution, this platform does not record your passwords or does not review your online account or even the content of your account. It also does not save credit card expiration dates or other sensitive information. In fact, it doesn't need any of this in order for it to work. It only needs to know that your online account exists. It's there to protect the integrity of your information in a secure server. The platform understands that security is a priority and your personal information is highly valued. Now again, this proprietary solution is made available just to our clients of Legacy Planning Law Group, and specifically to those clients with whom we have an ongoing relationship as part of our client care program. If you'd like this kind of protection and peace of mind, you'd have to become a client of Legacy Planning Law Group and be a member of our client care program. We'd love to have you as a client. So hey, if you'd like to know more about what happens to your online account when you die, and maybe you want to learn more about how we can help, we'd love to talk to you. And again, I encourage you, go ahead and reach out, schedule a free 15-minute discovery phone call. You can use the Book Now button here on the Facebook page, or you can Google us, Legacy Planning Law Group, or call us at 904-880-5554. This call is complimentary. So if you've enjoyed this, Hey, if you would like the video, better yet to share it. So hope you've enjoyed this talk. See you next Thursday. On behalf of Team Legacy, go make it a great day.